Thank you, Pierre, and thank you everybody else at the Spiral Research Center who's been involved in organizing this beautifully put together event. And thanks for the words of exaggerated welcome that were said at the very beginning. And I don't know whether any of us can live up to those promises of eminence, brilliance, talent, and whatever else. But in any case, let me try out a few ideas. One thing that I've been struck by is how trading zone has proved to be extremely productive, but maybe in the wrong kind of way. That is, in playing avoidance games. People have talked about very interesting things and not really engaged with whatever this metaphor of trading zone is supposed to be about. I was thinking about how infinitely ambiguous those two words are, and one could think about trading zone in the same syntactic frame as David Lodge, the British humorist, his novel Changing Places. So you trade one zone for another, not that it is a zone in which you conduct trading. And I mean, so that's one way to think about it. And I think my talk probably fits with more that kind of understanding. I want to change the zone from the ones that we've been in to some other kinds of zones. And also in my talk, I'll talk about how people change zones in which they're active in various ways. And then trading, of course, is itself a market metaphor and an economic metaphor, and therefore zones in which marketized behavior or market-like behavior are conducted. And one of the things you'll hear in my talk is about the way in which, at the frontiers of the life sciences, particularly in the interaction between biology and law, one of the ways in which the questions of how we govern and who governs, how these questions present themselves, is through a question about what belongs in tradable areas, so what is marketable and what is not. So let me So let me start in with the talk and say that one of the things that I think characterizes my work in particular is an attempt to connect the ways in which we want to think about science and technology with normativity in different ways. And I think that that's a very general theme that you've already heard in the other two keynote talks in very interesting ways. And I hope we'll come back to this question as one of the animating questions for our discussion. I know there are other law-trained people in the room as well, so for them also, the epistemic normative conjunction is one that is obviously extremely important. So what I want to do is first talk about some theoretical ways of going about thinking about these things. This is not in order. These are the things that I want to do. Secondly, I want to do it in part by disentangling a discourse on life and a discourse on law, and that's, broadly speaking, the scientific and the legal and political. In line with some of my own work, I want to be explicitly comparative. And then there will be some conclusions which are more things to think with and things that we will depart from in the general discussion. So I want to make a kind of argument about deriving from the comparative work that I will go into in more detail with you in a moment. I want to say that if you look at my three comparison countries that I've spent a lot of time studying and thinking about, the UK, Germany, and the US, that in each of these you see a particular stylized, to pick up on Andy's word, cultural, acculturated way of connecting public knowledge with concerns about normativity. And that these particular ways connect with, in interesting ways, with an idea that I have been calling lately in my work the governable subject. That is, what is the nature of the subject that is being governed in these systems? So very briefly, in the UK, I think that the kind of epistemic foundation or epistemic correlate of the governance systems that are produced is common sense knowledge, and then that ties to a way of governing in which there is a convergence produced at both the epistemic and the normative level between the state and science, and the governable subject in that system, to invert the well-known title of the book by James Scott, Seeing Like a State, it's that the subject sees like the state, or at least the enterprise of the state, is dedicated to producing subjects who see like the state, and then a lot of attention is devoted to how, and I'll look at the details of this in a minute. In Germany, it's not the co-produced common sense and governing beliefs, but rather the law being taken as a baseline for defining humans and human integrity, and then science's facts are fitted into that normative structure, and the governable subject is one who is seen as respecting the dignity of life in the ways that it is understood in the German legal system. And in the US, science is kept apart from politics. This is something that, of course, I've been arguing for a very long time as a salient feature of American political culture. But this happens through practices that do the kind of linear progression that you've already heard about in both of the previous talks. And the governable subject is one who knows how to behave in the public sector and the private sector, respectively. So the governable subject is someone who well understands the distinction between being a consumer and a citizen, and when to be a consumer and when to be a citizen. And of course, sometimes the citizen, the good citizen, is also the good consumer. And again, we will look at how this is done in a bit more detail. So the theoretical fundamental foundations for some of what I'm going to say are in this idea of bioconstitutionalism, and I have to give credit to Science Magazine on the occasion of the 10th anniversary of the decoding, well, the mapping and sequencing of the human genome. They asked people to write 200-word little essays, and then they wanted to illustrate these, and so they came up with this illustration that combines the bio and the constitution, and I had their permission to use it both as the cover image for my book, and I mean, this was one of the times when I think our Athérisement produced an object for me from the high echelons of the scientific enterprise, so I'm quite grateful to them for having produced this image for me. But the idea in words has to do with the ways in which life and law mesh together at the constitutional level. And, you know, the insight that this departs from is that if you change the definition of the human, as we are doing in a number of different frontiers areas of science and technology, then the entire system of rights and obligations and duties and what the relationship is between the subject and the ruler, all of these things have to get rewritten one way or another, tacitly or explicitly, and both the tacit and the explicit are going on in various different kinds of ways that we can look at. While I talk mainly about, or thus far have talked mainly about biology, those of you who are interested in information and the digital era will recognize that there are numerous parallels between the bio world and the info world. I've, to some degree, started saying that whereas we each used to think of ourselves not that long ago as human subjects sort of sitting like you're all sitting in your phenotypic variability, you know, looking different and speaking to some extent different languages and so on and so forth, we now have these shadow other persons that we're less aware of, the biological person and the informational person, and that a lot of the concerns of the law today, particularly at the constitutional level, are how to treat this subject that's now trifurcated between the touchable real one and these two virtual ones, the genetic subject and the informational subject. So some of the problems for the law And some of the deeper conceptual problems for human nature, human integrity, survival of the human species, all of these things to some extent are related to the fact that we have in some sense become exploded into multiple personhoods that nevertheless are attached in some interesting ways to one another. So the bioconstitutional settlements and decisions occur through this process that some of you know I call ontological surgery, where a platonic divide is created between things that we care about and don't care about at all, or things that we care about in one way and not in a different way. So this is where trading zones might come into play, because we might care about somebody as a living being who is entitled to the full protection of the law, or we might care about something as property that is also entitled to protection, but for entirely different reasons and possibly under different legal regimes and different understandings. So ontological surgery is the moment at which, or the process through which over time those kinds of sortings out happen, and then you have entitlements that shift in consequence of that surgery or surgical process, and things like rights and dignity and property get sorted out in those moments. So most of the empirical examples in this talk will be taken from the domain of embryos, in vitro fertilization, and the family more generally. So arguably, there's been a process that's been going on for a while that you might think of as molecularizing the family. And it has happened because new status is being granted to elements of the reproductive process that were not thought of as separate entities in the past. So gametes, the sperm and the egg, you know, what is their relationship to parentage writ large? I'll come back to that when I talk about the US case. And of course, there are a series of technological procedures and practices that go with the fact that you're now doing these things to gametes that are involved in reproduction. Embryos themselves, because embryos have become things that exist outside the body as well as inside the body. And again, there are technical practices associated with the production of these entities that belong in some sense to family structures, but we're not quite sure in what sense. Clones, and whether we can or cannot produce them and under what circumstances, and again technical practices associated with that, and stem cells, which have become kind of ubiquitous in biomedicine, but again they bear some kind of relationship to the grown-up or the real or the perceptual, you know, human self, and the relationship is being talked about in various ways. All right, so with that, let me shift into the comparative gear. And one of the things I want to point out methodologically, at least about my method, if you can call it that, I should put in a caveat. When I first learned to write NSF grants, I didn't have any of the baggage that you're taught you absolutely have to have a successful career. I had no role models, I had no sponsors, I had no department, and here I was left to fend for myself, and I suddenly had to write a National Science Foundation grant, and I had no clue, having never done this before, and you know, and I was told that there had to be a method section, and to this day I have a little frisson of terror when I see the word method, because my method has always been pretty unmethodical, and now here I am forced to teach other people who are supposed to go out and get jobs because they studied with Sheila Jasanoff and learned some method. So, I mean, you know, keep in mind that there's a great deal of need for self-ironicizing in the business that we're in all of STS. But comparative method, well, one of the things I learned early on is that whereas most comparatists have this idea that you take an issue and you look at the same issue in a number of countries side by side, that much more interesting things emerge if you think thematically about these things. So my three examples of where bioconstitutional moments of theoretical interest are happening in the three countries are different. They're radically different in each of the cases, but the kinds of issues being raised about the governable subject and the construction of the governable subject, I say, is what holds these cases together. So I've started talking about it as comparative problematization, using the Foucauldian idea of problematization. And, you know, if you could plug in matter of concern, I mean, you could do various things, but showing that Anglophone people do read French, which is a nice language indeed. But I'm not too wedded to the terminology. I mean, being a good Anglo-style empiricist, I still feel I know it when I see it as a good research site. All right, so the UK case concerns a debate over the Human Fertilization and Embryology Authority, hereafter HFEA, and its existence, its continued existence after it was felt that it had adequately normalized the territory of IVF and stem cells and all of this kind of stuff. So we begin with, well, there are two major and very important female characters in this little story I want to tell you. One is the Baroness Mary Warnock, who is known to all the bio people in this room as having spearheaded the Warnock Committee report, probably the most famous ethics committee report produced in the last 25 or 30 years. And she, her committee laid down the blueprint for what later became the HFEA. And then I want to take I think the just past director, not the present one, of the HFEA, who's the Renaissance historian, Lisa Jardine, and I want to talk a little bit about the continuities between the visions of these people at the nexus of creating the common sense-based governable subject that I say is characteristic of the UK. So this first bit, so the governing question, the question in a democratic system is not just how do people get authorized to rule for other people. I mean, we have elections in this country. You actually make it a requirement that people vote. We don't, so we have 60% or lower turnout in our national elections. In Belgium, you have 90% or something like that, and the others get fined, as far as I know, or something. I mean, there's some sanction, right? I mean, you know, so we don't have any of that. We try to keep people from going to the polls. But more interestingly for STSers, there's a question, how does one get to see for the people? And this, I think, connects totally directly to what Andy was talking about when he was talking about how the power gets into the knowledge systems, and that much before you get into trading zone metaphors, you already have a powering up, as it were, of the knowledge dimension. So how do people in the common sense world of British empiricism and British political culture get to see for the people? And the Warnock thing is in my book, Designs on Nature. I do still think that it is an absolutely beautiful moment at which all of this is illustrated, because at a key moment in the House of Lords debate, before the passage of the law that creates the HFEA, there's a certain amount of disputation, people going back and forth, and some people saying, you know, really the embryo's life begins at day 0 or 1, and you can't really have a dividing line at 14 days like the committee recommended. And then Mary Warnock herself gets up to speak, and she says, there is a very noble prayer frequently uttered in my college chapel. By then she is Mistress of Girton, a kind of title that only the British could invent, and maintain alive for century after century as well. I mean, the continuity of institutions matters. But then this was the key term that caught me, that we may be given the grace to distinguish things that matter. I mean, if you're, of course, imbued with a certain amount of the beauty of the English language, which is genuine and it is beautiful, then you recognize the poetic beauty of the statement, be given the grace to distinguish things that matter. And grace, borrowed, of course, from French, is one of these beautiful words anyway. So it makes you wonder how mere philosopher, who by then is Lady Warnock. I mean, she's not yet Baroness at that point, I don't think, but she's also the head of a Cambridge house. How does she get the grace? And it's through prayer. And it's in a country that has the resources of established religion to draw on in rhetoric. I mean, obviously, nobody in Britain goes to church, and I mean, you know, there's all of that. But nevertheless, the rhetorical resources exist and are there. So in a bit of textual sleuthing that required me to correspond with the then chaplain of Girton College, I tried to track down the noble prayer that she was talking about, and I believe I did track it down, and it's quite beautiful, and it's Thomas à Kempis's prayer built on an ancient Greek text. But note what it says: grant me, O Lord, to know what is worth knowing, to love what is worth loving, and so on. But do not let me judge by what I see, nor pass sentence according to what I hear, but to judge rightly between things that differ, and above all to search and to do what pleases you, through Jesus Christ our Lord. Amen. So, you know, I mean, who says that religion is dead? I mean, it's available very much as a secular resource, but in that moment, the seeing for the people is justified. Again, Andy, you use the language of justification. My language, as you know, is public reason. And it's justified, Pierre Benoit, with language as a vessel that actually bears some very powerful strains of meaning that you can't get rid of in some way. But at the end of it, Mary Warnock, plain old human being as she is, becomes the vessel through which the entire majesty of church and state speak, you know, for the people, to make the Platonic distinction between the real connections and disjunctions, and the ontological surgery is perfect. But it's not just her, because much later, Lisa Jardine, who is the daughter of Bronowski and herself a part of the British establishment, draws on her Renaissance history to do some of the same kind of stuff. I mean, so she is interviewed in The Guardian when she takes on the headship of the British HFEA. Now, in America, if you had a comparable authority, it would never be headed by a humanist historian. It would be headed by somebody who was considered to be a specialist in bioethics or something like that. So even in the appointment of this person who is not qualified by special training to make these ethical judgments, you're already seeing some of my constitutional system of Britain at work. And she says, St. Augustine, who I greatly revere, believed that the child became human when it kicked in the womb. So again, a commonsensical position that the pre-14-day baby or embryo is not a real person, but the weight of church history being mobilized to make this point. And then my favorite bit of this quote is that she attributes I mean, she makes it seem like an act of extremism and more of a recent historical invention, that some people are claiming that life begins before 14 days, because she finds no historical basis for this. And there are thinking Catholics who I greatly respect, who genuinely believe the Catholic Church should roll that back, in which case we'd all be able to talk to one another. I mean, you know, there's this construction of what the right polity is and what right thinking is, undergirded with historical sentiment, but in a language that makes everything self-evident, you know, everything acceptable, and so on and so forth. So that organization that Warnock's committee underwrote and that Jardine became head of, came under fire when the government changed to elect the preceding coalition government of David Cameron. And one of the things that they wanted to do immediately was roll back government, and rolling back government meant doing away with these quasi-autonomous, non-governmental organizations, or quangos, and so much did they want to do away with all these bodies that it was actually called a bonfire of the quangos, and one of the bodies that they listed for elimination was the HFEA. So what's interesting, and we can't go into it in huge detail here, but HFEA survived, and HFEA survived because even the Cameron government, after it took the pulse of the people, recognized that it was forming a co-productionist state of affairs in which the British public would see like the state and agree that the kinds of conclusions they were reaching were indeed the right kind of conclusions to be reached. And there's a much more detailed exposition of all of this in a paper I have that in as yet unpublished form that I'd be happy to share if anyone is interested. So there was a review undertaken of whether HFEA should be merged with other bodies in a kind of streamlining of the research policy process, and the conclusion was no, it should not. And it was led by a civil servant, McCracken. And again, what he says is interesting. Public confidence in the sensitive areas regulated by the HFEA is high. So the test here is public confidence, and the importance of avoiding making changes that would pose a significant risk to this confidence was stressed by many people. So as some of you know, and one of the things I've stressed in my analysis of British political culture is the importance of the safe hands. And the safe hands can be particular people, or they can be particular institutions. And in a kind of instantiation of this, the meeting that Andy and I were at yesterday, the British science advisor went out of his way to mention, just en passant, that HFEA is one of the achievements of the British state. I mean, so he's, of course, erasing the history where the government he is serving tried to get rid of HFEA. But there's something invested in this particular structure, which I say is like a machine for creating that alliance, the epistemic, political, legal alliance between the kind of subject that the British government likes to rule and is capable of ruling, and the kind of knowledges that are being produced in the domain of IVF and, you know, across this entire domain of assisted reproduction, stem cell biology, and so on. And this has been consequential because things that are very controversial or not allowed in other countries are allowed in Britain, like the three-parent embryo. You know, there's actually, I think the science advisor mentioned this as a specific achievement, that basically anything that's happening on the forefront of reproductive biology, stem cells, and so forth, British science, of course, eagerly wants to go there. Everybody else's science also wants to go there, but there are fewer breaks, in part because of the HFEA's role in manufacturing a particular kind of alliance between seeing and governing, if you will. Right, so the second example, and I'll go through these a little more quickly, is in Germany, the prenatal genetic diagnosis case, in which you see years of debate with some back and forth over whether prenatal genetic diagnosis, or pre-implantation genetic diagnosis is an allowable thing or not. And there it centers on Germany's extremely rigid definition of when life begins, which is biologically completely different from what is understood in many other countries. So life is thought, well, for legal purposes, it begins at the moment when there is nucleofusion between the sperm and the egg. Before that, once the fertilized embryo starts dividing and you can extract cells from it, those cells are considered to be pluripotent, so not totipotent, and that too has been, you know, part of the question for German reproductive procedures. At what moments is it okay to intervene in embryonic life and extract one kind of cellular matter or not? So a few years ago, there was a test case brought by a Berlin physician who decided that he would test the proposition that in Germany you could not conduct tests for genetic illness on pre-implantation embryos in order to determine which ones were suitable for implanting and bringing to term or not. It was thought that German law prohibited that kind of intervention. So he chose to conduct a test which did not involve destroying the embryo under German law, and then he implanted the embryos that looked healthy, and then he turned himself in, saying, look, I've done this, now you decide if I'm guilty or not. And eventually the German courts decided that he was not guilty, but how they came to that conclusion, again, sheds light on this governable subject point. So several things are important, whereas the HFEA is this itself a liminal agency that lives between public and private. There's no question that whatever settlement was ultimately reached in Germany would have to be reached by Parliament. Even a court decision, as we'll see in a moment, was not enough. It had to be ratified by Parliament because Parliament produces the legal clarity that is needed in order to produce the governable subject. And then in the Bundestag, there were different debates, and they centered around the German famous Article 1.1 obligation of the state to protect human dignity and not to compromise it in any way. And rhetorically, this is what the legislators were hung up on. Our society loses its humanness if we allow a paradigm shift which enables others to decide which life is worthy of living and which is not. So the testing, the pre-implantation testing, was seen as impermissible selection, and selection that was contrary to the principles of human dignity. Whereas the left, well, I mean, on this, actually, the right and the left, to some degree, came together because, you know, there are certain prohibitions in German discourse and German law against ruling some kinds of life as being unworthy of existence. But then a compromise position was ultimately found. The issue that we put in front of the liberal state of law, or the Rechtsstaat, reads, how do we treat individuals in such severe distress who have taken a decision for PGD? Do we subject them to rigid morality via penal law, or do we treat them as self-determined, responsibly acting human beings who want to spare their children from the most severe burdens? I mean, so, of course, you will recognize certain kinds of boundary work being done in the law, but more than that, you will recognize that instead of the embryos being seen as a site of unnatural and illegal selection, the embryo is now being seen as a participant in a set of familial relationships where other people also have obligations, and the parent's distress matters as much as the child. So is the law really in the business of getting in there and saying parents, in order to save the embryo its distress, must go through the distress of either bringing a child to term and watching it die, or of undergoing an abortion because the child is found to be defective while still in the womb? And so the court ruled, a court ruled that in Mr. Blöchler's case, he was not responsible and liable, but ultimately it had to go to Parliament, and Parliament has now enacted a PGD exception, very tightly circumscribed, but inside of the law that protects embryos. So again, the settlement had to be ratified through formal law. It couldn't be left in the discretionary space of the HFEA, as it could in the British case. In the US case, so you could say that in both the British case and the German case, coherence was achieved. Just how coherence was achieved was different. Whereas in the US case, incoherence exists quite happily and you know, periodically becomes political as well. So incoherence exists around what exactly is regulated and what is not. So abortion is regulated and IVF is not, but by and large, IVF is very poorly regulated. So what the status of an IVF, in vitro fertilization, embryo is very unclear in American law and practice. And then the formation of the governable subject, whether that embryo actually belongs in the class of governable subjects, is also left to some extent incoherent through a partition being erected between what is the state's job and what is the market's job. So this is reflected partly in a discourse about parenting, whether it's biological or social. And in this very famous case, Johnson versus Calvert, 20 years ago, the California Supreme Court had to decide what makes a mother a natural mother. And I'll come back to the decision in a second, but you see that this discourse of, what's natural or unnatural in motherhood continues as a newspaper item, partly getting caught up in the law lag narrative, and I like this Boston Globe question: what does make a father? Diapers or DNA? I mean, I was just talking to a relatively new father who will appreciate the question. Maybe it's neither, but it's put in that way. So where the biological ends and the social begins is a matter of sort of generalized discourse in the country. So in the Johnson versus Calvert case, the court decided that gestation, the 9 months of carrying a child to term, is a service and is in the market, whereas donating the actual genetic material goes with an intention to produce a child, and therefore that is what the natural parenthood attaches to, not to the gestation. So they partitioned the reproductive process into a market part, a trading part, if you will, and it became part of the zone of the market, whereas the other part, the donation of the egg, became part of the sort of standard naturalized reproductive process and untouchable in that sense. And there have been a couple of other California and other cases. The funniest one is this Wazanka versus Wazanka, in which a baby was born, and initially a California court ruled that it had no parents, even though there were 5 claimants to parenthood. So there was the couple that originally wanted to produce this child, there was the egg donor, there was the sperm donor, neither of them the original couple, and then there was a surrogate woman who brought the child to term. And afterwards, the sperm donor said he didn't want to have anything to do with this baby. He didn't want his ex-wife to have anything to do with the baby either, because then he felt he would be brought in and made responsible in the market for the upkeep of this child. So they denied parenthood. Of course, the egg donor and sperm donor said, we were just donating egg and sperm. That was a market transaction. We're not the parents. And the surrogate mother said, by prior law, Johnson versus Calvert, I'm providing a service. I mean, so everybody suddenly became a market agent, and so there were no natural parents left at all, according to one court. And then, the court ends up generalizing the language of intention to say that the people who intended to produce the child, even though no biological material changed hands, were the real natural parents. And then, lastly, there are continuing battles over what constitutes adoption and what not. A recent New Jersey case was decided on the basis of equality because infertile husbands and wives were being treated differently. Again, we don't have time to delve into the details of the cases, but what matters is what kind of agency is being attributed. Is it biological agency? Is it tradable agency, if you will, and how is it being done? That's what is illustrated in these cases. So very quickly on the stem cells, there are different ways of narrating the stem cell. Is it a scientific procedure? Is it something that is easily demarcated? I mean, these are standard scientific illustrations. Or is it a proto-child that is being brought into the world in that moment? And many of the American political debates around stem cells are about that. And you can talk about the stem cell narratives as breaking down. This is sort of similar to Pierre Benoit's findings about the different innovation discourses and methods, in that there are 2 side-by-side narratives going on, each of which locates the stem cell in a different constellation with respect to life and family and other social appurtenances. And again, mindful of time issues, I'm just going to say that keep this in mind, that narratives matter, and a lot of the politics of stem cells is around which narrative is going to be made governing and how. And interestingly, the bioethics capability has moved into the executive branch in the States. So this is not the case in Germany, where it remains very much in the legislative branch. The parliament has to authorize, and did authorize, the German Ethics Council, and it's not in this liminal state where the HFEA belongs, but the history goes way back. Margaret Thatcher did not want bioethics to be a governmental function. She thought that that would be problematic for government, and so bioethics was privatized in Britain, or quasi-privatized, a very long time ago. Whereas in America, it has become a thing that presidential politics is playing with all the time. And presidential politics makes judgments about ontological surgery, which, as a constitutional matter, they should not be doing, in a sense. So the Supreme Court of the United States, which is the custodian of the meaning of the Constitution, has not articulated when life begins. This is unlike what has happened in the courts in some other countries. But nevertheless, George W. Bush seemed to know when life begins and when it doesn't, and he does ontological surgery when he says things like, there should be no state support for science which destroys life in order to save life. So he is making a commensurability, an STS-style equivalences judgment, and thereby declaring some things to be in the moral community that, as a matter of formal law, are not in the moral community. But Obama does his own ontological surgery there when he says more funds can be used for stem cell research, but he does it by creating other moral lines. So we will ensure that our government never opens the door to the use of cloning for human reproduction. So it's creating some bright lines of a legal I mean, he's performing constitutional legislation there, and it's, you know, just important to see where this is happening. All right, so if one compares, I mean, you know, you can put some of this together and you can see that point by point through the entire reproductive phenomenon, the three countries are doing different kinds of settlements. So what needs to be consistent, what can remain incoherent, what is the basic ontological claim about life, what are the risks involved, who are the interests that are being served or protected or whatever, where does the supervisory authority really belong, in what body of law or what body of practice, and then what constitutes an abuse in this domain of, I mean, so how do we know, if we're interested in democratic politics, that the authority to make ontological distinctions and having the governable subject be created, when is it being overstepped and how do we know it? And all of these, my three countries, differ quite fundamentally. So you can say that what is being created is a kind of reciprocal constitution making, and that it's multi-sided. Reciprocal because science and law are engaged in this sort of tacit mutual dance in serving each other, and they each rely on the other to produce the conditions of possibility for their own legitimacy and legitimation. Law constructs science as providing facts which then serve to undergird whether there is a reasonable matter of legal concern or not. Law constructs, I mean, science constructs law by saying that law is refusing to act in relation to the facts that science has already found. That is a kind of deficit model of the law. So it's not usually talked about in STS, but it's interesting that science in America constructs law routinely, and not just in America either, that law, this most ancient and powerful of human institutions, is in today's society seen to be in a constant deficit, just like people are. I mean, so why bother with a demos? Why bother with law if they're constantly in deficit? And we may as well allow science to step forward and do the constitution making of the imperial structures that we were already hearing about. So, you know, so then the question for comparative analysis is, where do the bright lines come from in each of the national traditions? And right, so I think that was where I was going to leave it, unless I skipped over a slide, but it's well, I don't, anyway, I don't want to run through the whole thing. Yeah, so let's just leave it there. I mean, what I hope I've pointed out is that the value of comparison in sort of pointing our attention to how the very act of governance and the very decision about the legitimacy of governance is being created at these moving frontiers of one particular technological sector. I think a very similar kind of analysis could be done with respect to other technological sectors, certainly the informational, but I suspect also older technologies. I suspect one could look at nuclear, in similar sorts of terms. So with that, let me stop.